we're also live on our YouTube page. Firstly, let me thank you very much for taking out time and agreeing to come on this forum to deliver this lecture, Justice Lokur. It's a cliche often to say that one does not require an introduction, but I'm sure in your case it's entirely true. Many of us lawyers have appeared before Justice Lokur in the Delhi High Court, in the Guwahati High Court, in the Andhra Pradesh High Court, and of course in the Supreme Court of India. He has been a pioneer of the e-courts initiative in the judiciary, with social distancing being the need of the hour and the government having responded to it with the lockdown. The judiciary and the legal profession was thrown in the deep end and made to adopt platforms which it had not adopted uh, before this. So Justice Lokur is here to talk to us about e-courts and virtual advocacy and the way forward. Now with this, sir, why don't I hand it over to you and request you to virtually deliver your lecture.
Yeah. Okay, thank you. And thanks to EP Conversations that you're giving me this opportunity to discuss a few things with you. Today we're talking a lot about technology and video conferencing, e-filing, and so on, which is necessary, of course. There's no doubt about it. But I would just like to go back in time a little bit to give you an idea about the e-courts project and why I think some of the challenges that we are facing today are not insurmountable. They can be easily surmounted, and we should be ready to go into technology-driven justice delivery. I don't think it's a problem. So what I have done is, I have tried to divide my lecture into 4 segments. One is the background about the e-courts project and the computerization project that has been going on in the country. The second segment is about some of the challenges that were faced at that point of time. And to some extent, some of these challenges continue even today. The third segment is what is happening today because of the COVID-19 virus. And the fourth segment is the way forward. So I'll just go in that sequence. Now, the e-courts project was conceptualized sometime in, I think, 2004 or 2005 by Justice Lahoti when he was the Chief Justice. And the first chairperson in charge of the e-courts committee or the e-courts project was Justice Bharuka, who was a former judge of the Patna High Court and then of the Karnataka High Court. So that's how it started, and he was very concerned with phase 1, which meant having a policy and action document and so on and so forth. I came into the scene in 2012 when I was appointed to the Supreme Court. Justice Kapadia was then the Chief Justice, and he requested me to take over the e-courts project and the e-committee. So my involvement has been for about almost 7 years or so. The e-courts project was really for the district courts, in the sense that there were a lot of issues with getting into technology in the district courts. People were not familiar with computers. There was no software that was available, and the majority of the litigation, 95% I would assume, of the litigation is in the district courts. And so therefore the concentration was in the district courts. So there were 2 aspects to the project. The first one was providing hardware to the district courts. So earlier, laptops were given to the district judges, but the registry of the district courts did not have an adequate number of, perhaps very few of them had computers. So on the hardware front, we provided computers to the um, to the district courts. And that was one aspect. And the second aspect was that we had to develop a software that could be used conveniently. It should be user friendly. That could be used by the staff of the district courts and by the judges in the district courts, so that technology could be embedded in the system. Which also required, by the way, training not only of the staff but also of the judges. The purpose of the software was really for case management and for court management. How do you handle cases, in terms of volume, number, so on and so forth, identification, and so on. And once this, software stabilized, we called it CIS 1.0. Then later on 2.0, 3.0, then 3.1. And ultimately, we had this National Judicial Data Grid, which contains the information about every case that has been filed in every district court in the country. When I say every, I mean every, subject to the fact that the court has uploaded the information, but it's supposed to be there. Okay, then the idea was also not only to look after the requirements of the judiciary and the registry of the courts, but also to look after the requirements of lawyers and litigants. Now, many of them, particularly in the districts, were not familiar with computers. Many of them perhaps did not even have computers. And I'm talking about 2012, 13, 14. So we decided to go in for mobile applications. So a large number of mobile applications were prepared and ultimately consolidated into one application, which is being used by litigants across the country and by a very large number of lawyers. There's a special one that was made for judges, so that they are dealing with only their cases in their court. They're not concerned about anything else. So this mobile application, I think it has been a great success. You can easily find out the status of the case. You can schedule your cases. The calendar is there. If you're busy on a particular day, you can just go to the mobile app and find out. If for some reason you're unable to attend the court, you can get the next date of hearing from the mobile app. We had this push and pull system so that you could communicate with the district courts as well. Notwithstanding this, we found that many litigants, particularly those who were poor, did not have mobile phones, smartphones. So they were not in a position to receive the information. And that's when we decided to introduce the e-courts project and the National Judicial Data Grid to the e-Seva Kendras across the country. I'm given to understand that there are more than 3 lakh e-Seva Kendras across the country. And, for a nominal fee, I think they used to charge 5 rupees, and that's what they said that they would continue to charge. They charge 5 rupees, and a litigant can go to the e-Seva Kendra and find out what has happened in his case. So really, he does not necessarily have to go to the district court if he's staying in some taluka and his case is pending in the district headquarters and he doesn't have a smartphone. He can go to the e-Seva Kendra and find out what has happened in his case. So, this catered to the requirement of the judges at the district level. It catered to the registry at the district level. It catered to the requirements of the lawyers, and it catered to the requirements of the litigants. Now, so far as the judges are concerned and the staff is concerned, the judicial academies in all the states pitched in, and they conducted training programs for the judges, for the staff, and as the computerization process gathered momentum, people from other fields like prosecutors They also made a request that we would also like to have a training program. Some government officials, they also said, well, we would like to have a training program. So they were encouraged to come and undergo these kind of programs. Um, I would have preferred if the bar associations at the district level had also taken some initiative and either organized programs on their own, because in each district we have a nodal officer and we have a computer committee. So the district judge could have been approached for conducting training programs for lawyers, particularly those who had access to computers and who had access to smartphones. But unfortunately, this did not happen. Now, to make life simpler and to take forward the technological advances that were being made through mobile applications, we developed some software, particularly for mobile applications. One of them is called N-Step. The purpose of this N-Step is very interesting. You see, if you have to send a summons outside the district or outside the state, service becomes a problem. So if somebody from, in a particular case in Mumbai, from the city civil court, for example, if summons has to be served to somebody in Delhi, then the city civil court will send the summons to some person to the office of the district judge in Delhi. That district judge will mark it to the concerned section or whatever it is called, and they will then mark it to the process server. The process server will say, listen, I've already got so much of work and now I have to serve summons for somebody on behalf of somebody in Mumbai or Hyderabad or some other place. So, psychologically, the feeling is that, well, I'll do it later. Let me finish my work first, and this will have lowest priority. So, he will go a couple of days before the date, the returnable date, perhaps find the place locked, and give a report saying that I went to the place was locked, and again, fresh summons has to be issued. We found, that service of summons was as low in some instances as low as 10%, and perhaps not higher than 30% anywhere. So this N-Step, really the summons is transmitted electronically on a smartphone or through the computer to the concerned person. Going back to that example from the city civil court, it comes, supposing on the 1st of January summons is issued, the officer from the city civil court will send it to Delhi on 1st or maybe 2nd or maybe 3rd, doesn't matter. But it's like an SMS or an email. So it will be received immediately, and then forwarded to the concerned person. And that the entire thing is available on the computer. So if the process server, sits over that summons for 10 days or 15 days, well, his boss will know, the section officer will know that, he's not done anything about it for the last 10 days. And he will ask him, why are you not making an attempt to serve the defendant? So really there was this check, and some states, Maharashtra in particular, has, taken advantage of this N-Step, not only from one state from the state of Maharashtra to other state, but also within the districts. The other advantage of this is that when the process server goes, he may go to the wrong place, right? Or he may give a wrong report and say that, well, I went over there, it was locked. Now, how do you know that he actually went there? So, we said we will give smartphones to the process server, and through the GPS, we can find out whether he went to the place or not. He can take a photograph, of the locked door or of the locked house and say that, well, I went over there. This is the picture of the locked door. The GPS coordinates will be available, and then you know that he's gone to the right place. Otherwise, he can always go to some other place and say, well, I, found the place locked. So this has really been of, great advantage. Then we also introduced something called e-pay. So, payments can be made online. It's not only a question of court fees being paid online, but you could have disputed rent that is being paid online. You could have compensation claims that could be paid online. You could have in a matrimonial dispute, if something has to be paid to the wife or something has to be paid to the child, that could be done online. So this e-pay, again, there is an understanding with the State Bank of India across the country. And many of these states have, in fact, entered into that agreement with the state bank, and e-pay is now possible. So you don't have to actually go and make the payment, physical payment. You can just do it through your smartphone. So a lot of these things, actually helped in the process, not only the registry but also in streamlining, the various events that happen in a court. The last thing that I want to say on this topic is the introduction of e-filing and video conferencing. Now, video conferencing was introduced quite some time back. In fact, in Delhi, there was an understanding with Tihar jail, and when video conferencing was introduced, the cameras at that point of time were pretty expensive. And the Delhi government said that, listen, we are not going to spend so much of money on these cameras and, providing computers and so on and so forth, because it costs a lot. Tihar jail said, out of our budget, we will, finance those cameras. So we said, fine. And the estimate was, going on the basis of the cost of the cameras and equipment and so on, that they would recover their cost within 2 years. It would take about 2 years to recover the cost. But when this video conferencing with the jails started, they actually recovered their amount within 8 months. What was happening was that, some prisoners who were required to be produced in court in accordance with the CRPC, and it was only a formality, in the sense that trial was going on and they were required to be there during investigations or during the trial, they would be produced through video conferencing. And the judge would have the cameras available so that he could also see if the prisoner had been beaten up or if there was somebody standing behind him, prompting him and so on. So he was not, he was present, or the prisoner was present in court virtually, but not physically. And this saved a huge amount of money. And now in many of the states, including in Maharashtra, this practice is being followed of production through video conferencing. The state of Punjab and Haryana, under the Punjab and Haryana High Court, they've gone a step further, and where doctors are required to be produced for expert evidence, for proving a post-mortem report, for example, from PGI MER, that's a Postgraduate Institute of Medical Education and Research, a very prestigious hospital in Chandigarh. They don't have to come to court, they just appear through video conferencing. And this has proved so successful, in terms of money, that they have saved quite a lot of money, running into crores of rupees in terms of transport, TA, DA, these kind of things. More importantly, in terms of time, so that the doctor doesn't have to go, to the court, maybe drive down for 10, 15 minutes or half an hour or 1 hour, depending upon where the court is located, wait for the case to be called out, give evidence and then come back. Instead, it can be done from the hospital itself. So there's a huge amount of saving in terms of cost. And like I said, more importantly, in terms of time, so the doctor is available to treat patients. So this is, video conferencing. And then, of course, video conferencing has been tried out in family cases, particularly, divorce by mutual consent, to the extent that, there are some NRIs in some foreign countries. Their statements have been recorded through video conferencing. And I remember the first time when it was done, Dr. Abdul Kalam was the president of India. And he saw this in a newspaper. There was a small item in the newspaper saying that the husband was in the United States and his evidence was recorded. His statement was recorded by video conferencing. And President Abdul Kalam called the concerned judge and asked him about the modalities. So really, for matrimonial cases also, it has been used. We also introduced e-filing, with a manual which is available on the eCourts website on how to do the e-filing. But because of the conditions in the district courts where lawyers and litigants are not all that computer savvy or computer literate, e-filing has not actually taken off, but it is available. And one of the reasons why it was made available was that it could be replicated, with some few minor changes in the high courts. Now, this is where I come to the second segment, that is the challenges that were being faced. Now, unfortunately, these things don't happen overnight, obviously. So the high courts, not to be left behind in the computerization process, they started developing their own software. They started, going into the computerization process in their own way. Each high court had its own, different way of proceeding. Delhi High Court had one particular way. The Bombay High Court had another way. Madras High Court had another way. Rajasthan, all of them, they had their own ways. The idea was that there should be seamless integration between the district courts and the high court. So if something is filed in the district courts through e-filing and a revision has to be filed or a first appeal has to be filed, then you don't have to refile all those papers. You can just, extract them from the computer, right? Whatever details you want, whether it's the orders, whether it's the pleadings, whether it's the documents, everything could have been done in this seamless manner. But because of every high court going about it in their own way, that seamless integration has not been possible, except I must say in in criminal matters in Delhi. They have been able to integrate it. So when a criminal case is decided in the district courts in Delhi, and assuming the person is convicted of murder and he wants to file an appeal, well, he just has to file the memorandum of appeal and the High Court will get the entire record on the computer. If it's a death reference, well, even that is not required. Everything will come from the computer straight away and it's available on the desktop of the judges. This is one of the challenges, of the, I think unwillingness is a strong word, but of, the high courts not actually getting involved in the project for the purposes of seamless integration. That's one of the problems that we are facing today. But anyway, I'll come to that a little later. I believe that the leadership was in a sense lacking. That broad vision for the entire state was perhaps lacking, or there was a lack of commitment. I don't know. But this kind of seamless integration that was intended did not take place and has not taken place till today. The result is that on paper, I'm saying on paper, the district courts are technologically far ahead of the high courts. High courts don't have e-filing, right? The district courts have had it for a couple of years. High courts don't have video conferencing. The district courts have had it for a couple of years. High courts don't have electronic service of notice or process. The district courts have it. High courts don't have electronic payments. District courts have it. To some extent, some high courts have some of these things, but all of them don't have all these things. So in terms of technology, the district courts are far ahead of the high courts, if you look at it on an average. Now, one of the ways of this seamless integration of getting everybody together was to have process re-engineering, so that everything can be done through the computer, or at least update the processes. For example, I found in the state of Meghalaya, a witness will come to give evidence in court. Now he's entitled to some payment. I think in Mumbai you probably call it bhatta. Here in Delhi we call it diet money. So he's entitled to some diet money, which is his bus fare and a little bit for lunch or something. Assuming it's whatever, 20 rupees, 30 rupees, whatever it is. Now to collect that 20 rupees or 30 rupees, he has to come again. Maybe the next day he has to come, or he has to come after 2 days to collect that 30 rupees. So it really makes no sense. So why is it that the processes cannot be changed or cannot be modernized, so that if the person comes, he gives his evidence, and when he's going back, he gets his money? All right. Then in Delhi, I know that if you want to file a vakalatnama in the High Court, Vakil Patra, you have to affix a stamp of 2 rupees 65 paisa. Today, you will not get a stamp of 2 rupees 65 paisa at all. In fact, paisa is not even existing in the country now. So, this updating, I'm just giving some very simple examples, but this updating of the civil court manual and the criminal court manual and the rules of the High Court were required to be updated, upgraded. Many of them were there from colonial times. Some of them used annas. Maybe the younger lawyers have not even heard of annas. So we need to have that process re-engineering. Under the e-committee or the e-courts project, money was made available. Many of the high courts did not take the money to carry out the exercise of process re-engineering. But I'm sorry, 4 years we tried it out. We approached the Law Commission, we approached the high courts, we approached the registrars of the high courts, but the process re-engineering exercise was not done to our satisfaction at all. Some high courts had done a fairly good job, but did not modernize their rules and regulations, civil court manual, criminal court manual. This is, I think, a huge, huge challenge, because when you're talking about evidence, when you're talking about production of documents, it has to be sanctioned by law, and the rules and regulations that are framed by the High Court. So all this really is a very big challenge, which we were attempting for 4 years, but could not successfully complete the exercise. The second thing, which is why I said about perhaps a lack of leadership or lack of commitment, is that we had told the High Court under the e-courts project that you set up a cadre of experts. You recruit persons who are good in computers, as developers, as programmers. We gave draft rules that had been framed by some of the government institutions. We gave them, for example, the rules framed by the Rajya Sabha, right, and by 1 or 2 ministries or something. But I, as far as I'm aware, not a single high court has created this special cadre. We said, we'll give you money. You engage 6 programmers and 6 developers. We pay for them, for a period of 2 years, and utilize their services. Talk to the state government. State governments were reluctant to, sanction these posts. So that's why we said, we'll give you the money. But there was no follow-up. And unless you have the specialized cadre, things will just drift along, which is not good. The third segment is what is the scenario today? The scenario today, all of you know, the courts are shut, virtually shut. There are some courts that are functioning, but nowhere near their capacity. There is talk of e-filing. People are now waking up to e-filing. There is talk of video conferencing, virtual presence, and so on. There are some negatives. Some people have said that this will benefit only a few people. The Bar Council of India, for example, has said that 90% of the lawyers do not have access to computers. So you're going to create a group of lawyers who are computer savvy. They are the only ones who will benefit. 90% of the lawyers, will be left out. So that's not good. But the fact is that all this activity that is going on for the purpose of e-filing and video conferencing is temporary. It's because of the present lockdown. And the Supreme Court Bar Association, the Supreme Court Advocates on Record Association has requested the Supreme Court that video conferencing should not be the new normal. Open hearing is definitely necessary. It should continue, and you could also have video conferencing, but don't give up open hearing. And it's very, very unlikely that any court will give up open hearing. Some of the problems that are being faced today, there is the bandwidth is not adequate. So very often, the picture becomes hazy. The lawyer is arguing, the picture becomes hazy. Sometimes the picture gets frozen. Sometimes the voice cracks, So these are issues that need to be tackled. I mean, there has to be sufficient bandwidth available so that these problems don't happen. And you can imagine, the frustration of the lawyer or the frustration of the judges. The lawyer is making submissions and suddenly, the face gets frozen and there's no voice, there's no audio. Then you're wondering, what's happening, right? So there are these problems that are being faced. One of the bigger problems really is the unfamiliarity with the medium. None of us are used to making submissions before the court, through a computer. Judges are, of course, not used to hearing submissions through a computer. So really, these are some of the issues that are being faced today. And there have been some, positive suggestions given by the Supreme Court Bar Association, by the Supreme Court Advocate on Record Association. There are some cautions, which have been advanced by the Bar Council of India. There is discussion about open justice. Now, if a lawyer has to argue a case, his instructing advocate is not going to be sitting in his, drawing room or wherever he's arguing from because of the lockdown. So how does he consult, right? Maybe the advocate on record wants to ask the litigant something. Perhaps the litigant, is not accessible on the net. The judges may want to consult with each other. They can't because they're sitting in, two different places. Theoretically, in the Supreme Court, they're sitting in one place. But then you have to shut off the audio, you have to shut off the video and consult. There are problems. You may want to refer to some books, some judgments. How do you do it? Do you tell the court in advance that, I'm going to cite the following decisions? And the court might say, well, what about this other decision? And then you're not ready with it because, you don't have it on your laptop. So there are, some problems. These are not insurmountable problems. They can be, taken care of. I would classify them virtually as, teething problems. You can't visualize everything, on the first day. So you're bound to have a little bit of, problems here and there. But like I said, they're not insurmountable and they're teething problems. But by and large, the number of cases that are being dealt with are very, very few. The Chief Justice of India said in an interview that on an average, about 205 cases are filed in the Supreme Court every day, right? But the cause list shows that there's only one bench that is sitting, occasionally two, but by and large, only one. And they have 10 or 15 cases before them. Now, if they're going to dispose of 10 or 15 cases as against 205 that are being filed, you can imagine what's going to happen. After the lockdown is lifted, there's going to be a deluge of cases. All those 205 multiplied by 40, right? that's I mean, suddenly you'll have this, like a dam bursting open. So these are problems that will arise. So now the last segment, the fourth segment, which is the way forward. I think the first thing that all of us should realize is that video conferencing or e-filing is only to supplement open hearing. It is not a substitute for open hearing. It is not to supplant open hearing. It is not to supplant regular filing that we know of. So this is, I think, one thing which has to be very, very clearly appreciated by everybody. That, well, you could have two parallel systems going on. I mean, the regular conventional courts that you have, and maybe in exceptional cases, hearing through video conferencing. The second thing to keep in mind is that social distancing it's here to stay. So what is the consequence of social distancing? One of the consequences of social distancing could be that the number of cases that get listed are few, maybe 10, 15, so that not too many lawyers and litigants come. That's not, according to me, that's not a good idea, because on what basis are you going to say only 10, 15 cases should be listed in each court? I mean, assuming there are 10 courts, even then you have 150 cases. Or if you have 20 courts, but you can't restrict the number of cases that are listed. It will create its own problems. The other solution to this is that, well, you list the right number of cases, as many as you want, 30, 40, 50, 60, but you limit the entry of lawyers and litigants in the court. So, maybe item number 1 to 10, you permit the lawyers and litigants to be there. And as and when, the items are over, they can start going out. And after the 10th item is over, then you have 11 to 20. So you have 11 to 20 coming in. Some sort of a system will have to be prepared. Lawyers and litigants like to be present in court, even if their case is not being taken up, just to see how the judges are reacting to certain submissions and so on. So you could have live streaming. That has been done in the Supreme Court for the press. They have a room where they have live streaming. So I think this can be done. Make live streaming available to everybody. I believe it was tried out in the Bombay High Court. Justice Patel had done that, and it seems to have worked quite well. Although I do remember Justice Patel telling me on another occasion that he was not particularly happy, when it was tried out the second or third time or something. But anyway, again, like I said, these are minor problems that can be taken care of. One very important thing that can be taken advantage of is by the e-filing process is that today, under the Supreme Court rules, petitions can be filed, SLPs or petitions, whatever, can be filed only by an advocate on record. And under the rules, the advocate on record must have his or her office within a radius of 25 kilometers of the Supreme Court. Now, if you're going to introduce e-filing, there are advocates on record in Chennai. There are advocates on record in Mumbai. There are advocates on record in Calcutta, in Hyderabad. Why should they not be allowed to file? If it's e-filing, how does it matter? I mean, it's not a question of physical distance. So I would very strongly recommend that advocates on record in different parts of the country should have access to e-filing. This will save a lot of time, money, effort for the litigants, for the lawyers. I mean, the litigant doesn't have to necessarily engage somebody from Delhi to do the filing. He can engage the advocate on record in Mumbai and say, all right, you file the case on my behalf. Yeah, and the registry can be in touch with that advocate on record through email, right? To remove objections and so on. So I think that this is one area that really should be looked at if you're going to go in for e-filing. Outstation lawyers might find it difficult to attend hearings, in the Supreme Court, for example. Airfares are going to go up. That's what the newspapers say. Lawyers may not want to come, to Delhi to argue a case, because of the potential of getting infected. Litigants may not want to pay, a very high airfare. I don't know about hotels. Hotel rates may also go up. So, the engaging a lawyer from outside Delhi to come and argue a case in the Supreme Court might turn out to be very expensive. Video conferencing is the answer. The lawyer can be in his, in a chamber, or can be in a studio in the, premises of the in the court premises, and make his submissions. If you look at it from the state point of view, well, every lawyer doesn't necessarily have to come to Mumbai or to Aurangabad or to Goa or to Nagpur. Maybe from some place, maybe some lawyer from Aurangabad can argue the case in Mumbai. Why not? Through video conferencing. A lawyer in Mumbai can argue the case in the Goa bench through video conferencing. So really, this has an advantage, but I think ultimately, some infrastructure will have to be made in the form of a studio. You can't have a lawyer sitting in his, sofa, or even sitting in his office, making submissions. The lawyers will have to get used to the idea of, making submissions while sitting down. Not many lawyers are comfortable with doing that. So these are small things, but they can be taken advantage of, through technology for outstation lawyers, outstation briefs, and so on. The Bar Council of India has said that 90% of the lawyers will get adversely impacted because they're not familiar with computers and so on and so forth. I don't think this is again a problem that is insurmountable. I think the Bar Council of India, the bar associations will have to be active. Some of you may remember that when banks were going to be computerized, there was a one-day strike or a two-day strike. The bank employees said, we're going to lose our jobs if you're going to have computers. That didn't happen, right? When mediation was being introduced in the country, lawyers said, we're going to be out of a job if you're going to introduce mediation. That didn't happen. I don't think computerization is going to result in any adverse impact for the lawyers. You can't stop technology. You can't stop development, on the apprehension that it's going to adversely impact somebody. These adjustments will need to be made. Some of the lawyers, some of the staff at the registry were wondering, we'll become redundant. It didn't happen. The officers in the registry are still there. In fact, in some cases, the number of officers have increased. Their workload has come down because of computers. So really that adjustment, will have to be made by the lawyers in the districts and the talukas. It's not an adjustment that they can make overnight. It's going to take time, but there's no hurry. Like I said, you're not going to give up open hearings. This is only going to be an additional, method of making submissions. So even if it takes a year, even if it takes 2 years, fine, nothing wrong with it, But I think the bar associations, the bar councils, Bar Council of India, Bar Council of the states, they will need to be a little proactive to get the, lawyers on board. There will, I think, also be a need to overhaul a lot of things. Processes will need to be overhauled. Methods of, presentation may need to be overhauled. Tomorrow, Monday, the United States Supreme Court is going to start hearing cases on telephone. They're not going for video conferencing. So the 9 judges are at different 9 locations. The lawyers are at different locations, and on telephone, they're going to hear it. That's an adjustment that they have to make. In England, online arguments are being addressed even now. So, this will require some sort of an overhaul of the system. Perhaps written submissions will become far more important than oral submissions. So drafting will become important. Being able to compress your arguments into something which is readable, rather than filing a 70-page written submission or a 100-page written submission, something which the judges can go through. I think that, these kind of changes will be required, and there will be a need to overhaul some of the, practices that we are following as of now. Presentation of submissions will also undergo a change. Like I said, if you're going to do it, through video conferencing, things like a PowerPoint presentation, for example, can be made. If you're dealing with, a public interest litigation about, say, something mining, or deforestation or whatever, and if there's a video available, it can be shown to the judges on the computer. Why not? But again, this will be a part of the overhaul process. So advantage can be taken of technology for giving more, visual arguments rather than only oral arguments. Today, it's very rare that judges are shown a video of something, or they're shown a PPT. In IPR cases, yes, you will put a photograph of one product and put a photograph of another product to say that A is passing off B or something of that kind. But this can become regular. Advertisements, one can be a disparaging advertisement. How do you find out whether it's a disparaging advertisement or not? It can be shown on the computer. So e-advocacy, will also require some change. There will need to be cooperation from several of the other agencies, like the police. Under the e-courts project, we said we'll share our data with you, except confidential data. But the police will also need to, switch over to things for technology purposes. FIRs, for example, why can they not share it with the courts? Why do they have to file it with the magistrate, and then it goes into a loop? It can be done electronically. Case management, can be streamlined. One of the problems that you're going to have is weather. Before this webinar started, the internet in Delhi was at my place was kind of not stable because of the weather. We had a bit of a thunderstorm. But yeah, these are things that one has to be prepared for. Last thing is something called virtual courts. We introduced something called virtual courts. What we're doing now is like an online court. A virtual court is where there's no judge, right? There's no lawyer, there's no litigant. We introduced that for traffic offenses. So if you get, a traffic challan saying that you jumped a traffic light, you go to the virtual court, and we had, told the magistrate that in all cases impose the minimum fine. You don't get into, 10% more or 20% more, just the bare minimum. So the person goes to the virtual court, which is on a computer, and he's asked, do you plead, he or she is asked, do you plead guilty? If the answer is yes, I plead guilty, then, this is the amount of fine that you will pay, 400 rupees, 500 rupees, whatever is the minimum. You make that online payment, right? And the case is closed. If you say, no, I don't plead guilty, then your case gets transferred to a regular court where you can appear, lead evidence, and say that, well, you did not jump the traffic light. Now, the advantage of that is that there are hundreds, if not thousands, of traffic challans that are being issued every day. I know in Delhi, definitely. So you have hundreds, if not thousands of people coming to the court to plead guilty and to pay that traffic challan. Whether it's 100 rupees or 500 rupees, they say, all right, we're pleading guilty and we make the payment. Those footfalls will vanish. You can do everything online. And when we introduced it, I think out of the first maybe couple of thousand or something, maybe there were only 10 or 15 people who said that, we do not plead guilty and we would like to have a trial. So their case was sent to the court and the court sent them a regular summons. So footfalls will decrease, right, which will make social distancing to an extent possible. We have done it for traffic challans. It's being used in parts of Maharashtra. I believe it's being used successfully in Pune. Tamil Nadu is also using it, and there's one more state that is using it. The idea is then to expand these virtual courts from traffic challans into other petty offenses. I make, payment of house tax after some delay. So I have to pay a fine or interest or whatever it is. Fine, I don't have to go there to, make that payment. I can do it online. Why not? Or there's some bylaw which I have violated, for which the punishment is fine, no imprisonment. I'll pay it. If I want to contest, sure, I can contest. I can say I don't plead guilty. I paid my house tax in time, or I did not violate whatever municipal law there was. But if I say, well, yeah, I'm sorry, I made a mistake, I plead guilty, I'll pay the fine. So really, this can reduce litigation to a very, very large extent. And there are no timings because the computer is on or the system is on 24 hours. So I can go to work, come back, go out for dinner, come back, and then say, all right, I plead guilty at 10 o'clock at night and pay the amount. So, there is a huge potential of going forward. It's just that all of us, need to think about it together. We can't, there's no way that we can change the system overnight. It can't be done even in a month. It can't be done even within 5 or 6 months. It's going to take a year at least. But a start has to be made. It has been made. We just have to go on and see how best we can do it. Adjustments will have to be made by just about everybody, by the registry, by the judges, by the lawyers, by the litigants. But like I said, it's not going to be that open hearings are over. That's out of the question. It's just not possible. There will be issues in criminal cases. So far we've been just talking mainly about civil cases, but there'll be issues in criminal cases. How do you tackle that? What is a fair trial? How do you make sure that there's nobody, in one corner of the room pointing a gun at me? How do you ensure that? So these are things that, we'll have to tackle them as we go ahead. So this is all that I have to say. And thank you very much for your patience. Thank you.
Thank you so much, sir. We have a few questions which we would like to put to you, if you don't mind.
Yeah.
Sir, the first question is, it's a very interesting one. It says, would virtual appearances affect the majesty of the court? This is in the context of the situation in Rajasthan where a lawyer appeared in an unprofessional manner for a virtual hearing. I think the person puts it very politely.
Yeah. I don't think so. Of course, rules will have to be framed. How do you conduct a video conference? One of the lawyers, of course, he said it jokingly. One of the senior lawyers said, I can't interrupt the other lawyer, because of this video conference. So, there is a procedure that will have to be laid down, that if you want to interrupt the other lawyer, raise your hand or do something, give an indication. So these rules will have to be framed, and they'll have framing rules is not easy. If you look at the civil court manual or the criminal court manual, they go into such great details. Now, even this inappropriate dress of that lawyer from Rajasthan, Tell me, are the judges in the Supreme Court not supposed to wear bands and the gown? Some of them have held court wearing a tie and a suit. Is that permissible? There is no standard operating procedure that has been laid down. So these things have to be thought of, But like I said, these are, not insurmountable, teething problems, and yeah, we just have to take it as it is and see how it goes.
So a common theme of questions is about e-judiciary and the access to justice. Would the technology act as an additional barrier for some to access justice, especially considering the access to internet being fairly limited in this country?
Yeah, like I said, there are some challenges. For example, bandwidth. Okay, now if the Supreme Court is facing this problem, I'm sure some taluka in some district in Maharashtra will also face this problem. So, but then we are looking at supplanting the existing system with video conferencing. We are not. Supposing a choice is given to a litigant that, listen, you can go to an open court, you want to go to Mumbai or you want to go to Pune, the district court, by all means. But if you feel you do not want to go and you want to, be wherever you are and try it out by video conferencing, why not? So really, access to justice is dependent entirely upon the litigant. What is legal aid all about? That's also access to justice. I don't have the money to go to court, so I go to legal aid. Now, can it be said that, I'm being denied justice? Perhaps not. So let's not assume, that video conferencing is going to completely replace open hearings. It's not. So it's, like I said, it's a supplement. So the litigant has a choice if he wants to, go in for video conferencing, and if the technology is available, bandwidth is available, studio is available, fine. If it's not, it's not. Today, it's not. So how are we? Why should anybody complain about access to justice today?
Just a couple of more questions, sir, if you don't mind.
Yeah.
Advocate Sachin Patil from Kolhapur asks that would paperless courts and e-filing render the demand for High Court and Supreme Court benches? Would it nullify the demand for High Court and Supreme Court benches?
I don't know. I think that is a decision that the court has to take. They may say that, well, everything is available now. So why do you want a bench in Kolhapur? They may say that, fine, let's have it in Kolhapur. I don't know. That's for them to decide.
And lastly, sir, there has been a movement by the government in terms of in areas such as the passport offices to introduce public-private partnership and technological measures to address people's concerns. Could such public-private partnership take place in respect of judiciary and technological development as well?
Yeah, there's a bit of a problem in that. The problem that I foresee is that if a private player gets into this, that private player will have all the data of all the cases. Now, I don't think that's a good thing. For example, in matrimonial cases, under the e-courts project, we do not disclose the name of the husband or of the wife, right? Sexual offense cases, we do not disclose the name of the victim, whether it's a child or whether it's a girl or whether it's a lady. We don't do that. Official Secrets Act, completely out of the question. Intelligence agencies, completely out of the question. Defamation, out of the question, because by transmitting it, you're probably continuing with that defamation. But then if a private player comes into all this, the private player will have access to all this information, and it can theoretically be misused. So I mean, prima facie, I think we should keep private players out of it, but ultimately the decision will have to be taken elsewhere.
Thank you very much, sir. We really appreciate your time and the effort that you have taken to deliver this talk. Although it seems from the talk, at least, that you did not need too much effort to come up with all these ideas. This clearly is a reflection of all the effort that you've put in over the years to try and introduce all these reforms in the judiciary.
Yeah, thank you.
I really appreciate you coming on this platform and speaking to all of us. I'd like to thank you on behalf of Deep Leaf once again, and hope you remain safe during these times.
Yeah, stay safe. Thank you and all the best. Yeah.
Thank you. For all our attendees, as usual, we will be uploading this talk on our YouTube channel, and the link will be shared on our social media pages. So if you want to go back and listen to this talk once again, please go to our social media pages. Lastly, tomorrow we have Mr. Abad Ponda, who's a senior advocate in the Bombay High Court, who will be delivering a talk on Article 21, arrests and liberty. So we hope many of you can join us for that as well. As we always say, stay safe in these times, and we hope to see you for all our future talks as well. Thank you very much.
Thank you.
Thank you, sir.